Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is William Mahan, who is an attorney in San Jose, California. I'm going to call him Bill. Bill is of counsel to Gates Eisenhart Dawson, a law firm here in Silicon Valley. He's been practicing law for 32 years. He has a master's in taxation degree that he received from Golden Gate University, and he has his law degree, or JD, from Santa Clara University. Bill's practice focuses on estate planning and probate and business planning. So Bill, thanks for joining me today.
Thank you.
Okay. Today, Bill and I are going to be talking about why you need a will. This is a really important topic to us, to try to encourage people to take some sort of action. So we hope that this discussion today will help in that regard. And we're going to have this posted on the internet at financialinsiderweekly.com. So if you have a friend or a family member that's been putting it off and maybe they need some encouragement or some information, you can tell them about the interview and they can take a look at it. So before we get started, I want to caution you, lawyers go to study this for years, and then they go to continuing education classes, and for days on some of these subjects. They have week-long estate conferences and what have you. And so we're not going to cover everything in 28 minutes. We're going to hit some highlights. The other thing is that Bill is a California attorney. I'm a California CPA. The laws vary from state to state. And so you need to seek help from an attorney in your community. And if you've got property in a lot of states, maybe even more than that. Okay, so let's get started. Bill, any guess about what percentage of the adult population that doesn't have a will?
Well, Michael, I thought you might ask me that question today, so I did a little bit of research this morning and discovered that as of earlier this year, the statistics show that roughly 75% of Americans will die without any kind of an estate plan.
Okay, wow, that's really significant. So only 25%, or about a fourth, 1 out of 4 people, had a will when they passed away. Why do you think people don't get a will?
Well, there's lots of reasons. I mean, it's not the kind of thing you wake up in the morning thinking, oh, I should have my will done today. So people procrastinate. It's like going to the dentist or something like that. They know they should do it, but they just put it off. But there are other reasons as well. It raises issues for people that sometimes they have trouble dealing with, like their own mortality, the fact that they are going to die, and not everyone likes to think about that. The other thing is sometimes it raises issues that people don't want to address. So, for example, if you have a second marriage and children from prior marriages, and you have to deal with who gets what, you're not going to make everybody happy probably. And so it's hard to raise these subjects. It's hard to deal with these subjects. Sometimes I have people who come and see me who start the process, and these subjects come up, and it either stops or slows down because they have to deal with them. So lots of reasons.
Right. So I think some people are afraid, they almost feel like it's bad luck. If I have a will, that means I'm going.
Yeah, I tell people the opposite. If they get the will, they're going to live.
That's the positive frame of mind. And there's the selling point. If you have it, then you don't have to worry about it. You're going to live longer.
Right.
Okay. Well, what eventually seems to motivate people to go ahead?
Well, sometimes it's just because they realize they need to do it, and they'll come in and take care of it. And oftentimes, if they're married people, it's the wife who motivates the husband to come in and do the estate plan. Not always, but oftentimes it is because you're doing things to protect your family and your children. But other times it's because of a major event in a person's life, a birth, a death in the family, an illness. you know, they've had an emergency trip to the hospital, and it basically, you know, really makes them realize
Wake up call.
yeah, things could happen. But oftentimes it's something as simple as a vacation or a trip where people, they realize they're going to leave town, they're going to be on the same airplane together, and they haven't done anything. And so they'll come to see an attorney to talk about setting up some kind of an estate plan, hopefully more than a day before they leave.
Right. Please. Okay. What happens if you don't have a will?
Well, the first question I ask people who come to see me for estate planning is, do you have any kind of estate planning, a will or a trust? And if they say no, then I say, well, actually you do, but it's the California Probate Code. And so unless your estate is going to pass entirely by beneficiary designation, like a life insurance policy or a retirement account, then it will go through what's called probate. And that means the California Probate Code will determine who's in charge of your estate, or the probate court will decide based on the probate code who's in charge of your estate and how it gets distributed, when it gets distributed.
Right. So, in other words, if you don't have a will, then the state of California has written one for you.
Right.
And the legislators have tried to guess what you would like to do with your property, and that may or may not agree with really what you would like to happen.
Right.
Okay.
It's really not crazy. I mean,
Yeah.
the idea is usually if you're married, it goes partially to a spouse and partially to children, or all to a spouse if it's community property. So there are assumptions, but they just may not be what you actually would have done yourself.
Right.
So the reason it's called a will is because you're telling people what your will is, what you want to have done. So obviously the benefit of doing a will is that you get to have your say.
Right. And also, if you have a will, as maybe we'll get into a little bit later, but you can have special provisions in there that's not going to be in that cookie cutter. So, you know, the idea of maybe a bypass trust or
Right. Or even just a trust for your children, which we'll talk about.
Yeah,
but
yeah, right.
something different than what happens under the probate code.
Right. Okay. Well, if you don't have a will, then what happens is, how do they figure out who the executor is going to be?
Well, again, the probate code has provisions. If you don't have a will, it's called intestacy. And the person who is going to be appointed to be in charge of your estate is not called an executor, it's called an administrator. The duties
Okay.
are the same, but it's a different name, so people can tell
Okay.
right away that we're dealing with intestacy. So the code tells us the different people that are possible, and it's usually based on relationship to the person who died. So it might be spouse, it might be children, it might be parents. It depends on who the people are that are the most closely related to the individual who passes away.
Right. And if none of those people there are available or willing, then they'll have to find somebody else.
Well, usually what happens, everything that happens in court is something that is brought to the court. That's 99% of what happens in court was brought to the court. So somebody will petition the probate court and say, I should be appointed executor. It could even be a creditor of the person who died, somebody who was owed money. So there's people that are entitled to apply to be the administrator, and if nobody ever does that, then there wouldn't be any probate of the estate at all. But that can create problems later.
Yeah. Well, somebody's going to petition for something. Okay. Well, what about small children? Are there any special considerations for them?
Yeah, there are plenty of. I mean, one of the main reasons people do estate planning, married people, if they have children, is because of the children. That's what
Right.
one of the things that motivates them.
Right. I think it's one of the most important things.
Yeah, and rightfully so, because what happens if you die and your children are young? Well, the first thing that's going to happen is somebody's going to be appointed their legal guardian, unless you have a trust, in which case you might have a trustee that can take care of things for them. But if we're talking about wills, so under a will, there would be somebody appointed their guardian, and that's a whole process that requires court proceedings. So another thing that people will do when they have children, in addition to a will, is they'll want to nominate the guardian for their children, so that whoever gets appointed is the person they picked. The other thing that's important about children is because they can't own the property, okay, if you have the guardian appointed, they're going to get the property when they become an adult, which in California is age 18.
Right.
So you have this proceeding that's going to go on until they're 18, which requires court appearances and expenses. But when they turn 18, they're going to get the property, which is very young. So the other main important consideration for young children, even if you're doing a will, would be to put a trust inside of the will. It's called a testamentary trust. And you name someone as trustee, and now instead of the guardian being in charge, it's the trustee who's in charge of the finances. So the estate goes into the probate court because it's in a will, but at the end of the probate, it goes into a trust with a trustee. The trustee manages it for the benefit of the children, paying for education and support and that kind of thing. But now you can decide how old the children have to be before they actually get the property. So they don't necessarily get it at age 18. You can give it to them at 21 or 25, or part at 25, part at 30, etc. So you have more control over when they get the benefit of the estate.
Right. So one important thing I think that you brought up is you may choose somebody different or is more appropriate for the care of your children, as far as, you know, raising them and so forth in your place, from who manages the assets.
Right.
So some people are good with kids, but they may not be so good in handling the money.
Right. An important aspect of the guardianship part of this for minors is that you can name the trustee, as I said, to manage the finances, and it may be somebody completely different than you would want them to be living with. But because they're minors, they are going to have to live with somebody. And so there is going to have to be a guardian of the person, and if you have the nomination in place, then you're the person in control of that, as opposed to just whoever applies to the court from your family to be appointed the guardian.
Okay. So what are some other things that you can do with the will besides naming an executor or a guardian for the children?
Well, of course, the most important thing is you're telling people who gets your property.
Uh-huh.
So you can decide, you know, who receives your assets, like your real estate, your investment accounts. Even if you're married, it doesn't necessarily have to all go to a spouse. If you have children or someone that you want to leave some assets to, you can do that. And also your personal property, you know, the things in your house, your cars, those kind of things.
Grandma's ring.
Yeah. Yeah. Also, a lot of people want to put special burial instructions in their will, or cremation instructions, and, you know, where the ashes are to be scattered and things like that. So those things are also appropriate for wills. And, you know, also sometimes people want to disinherit people, where, you know, the probate code is going to leave your estate to the people according to the law, just by their relationship. Well, you might want to leave somebody out for your own reasons, and if you don't have some kind of a will, you're not going to be able to do that.
Okay. And so one thing related to the burial instructions that I'll mention is, you know, it's a little bit of a problem area, because a lot of times people don't look at the will until after the person is buried. So it's really important, I think, for people to let their families know in advance and
Right.
have things, you know, readily available for them to find. You know, don't be too crafty about where you put these things.
Right. I mean, sometimes even people are traveling,
Uh-huh.
you know, and even if the will's back home, you know, if they wanted cremation, that isn't necessarily the first thing that's going to happen. So it is important for the people who would be contacted to know what you wanted, but also to know where the documents are that say what you wanted, so they have some authority for what they're requesting.
Okay. Well, now I'm going to get into some of the more difficult areas or whatever. What about thoughts related to adult children or children from a previous marriage?
Well, yeah, these are special problems, but quite common problems. And so, you know, a person has a certain amount of an estate. If they have a home and they have a second marriage, oftentimes that's where the spouse is living most of the time, right?
Yes.
So you aren't necessarily going to be able to leave your house to your children, or your half of the house to your children. That can create problems. So, I mean, these things are possible to do, but there are other alternative things that might be better to do. So if you have other kinds of assets that you could leave to children that aren't necessarily going to detract from the life of your surviving spouse, that would be better. And sometimes people have large enough estates where they can do that. Other times you can add things to an estate, such as life insurance,
Yes.
where the beneficiaries are adult children from a prior marriage or something like that, so that there's actually something for them It comes directly from the insurance company to them and doesn't have to be part of the estate and doesn't detract from what was left for the spouse. So there's all kinds of combinations of things that can be done, but there are ways of dealing with these problems that don't necessarily create hard feelings and difficulty. Depends on your insurability and all of that, but there are other ideas, that you can come up with that might alleviate the problem.
Right. I think a really important thing related to all this is that if you can, particularly if people are hopefully fairly compatible in your family, is to have like family meetings.
Right.
Or some people call them family councils.
Right.
But anyway, so where you get together and talk about really intentions and things like that, and so then at least things aren't going to be a shock. Now sometimes you can't avoid that because of whatever conflicts or what have you.
Right.
But if you can, it can really smooth things for when you do pass away later.
Yeah, if the people get along, it's probably a good idea to at least discuss things with them. There's a balance here because I don't like to do estate planning by committee or by board of directors. So that's where the attorney, I feel I have to sort of draw the line, is I have to do the estate planning for the individual or the husband and wife if they're doing it together. So they certainly want to not surprise anybody if they can help it, and get if everybody can sit around and talk about these things, I think it would help, as long as everybody kind of knows where they are in the scheme of things in terms of the decision making that's going to be going on.
Right. Well, these days, I guess about half of marriages end in divorce, and there are a lot of second marriages. People are trying again. What are some thoughts that you have related to second marriages and wills and so forth?
Well, some we've talked about, which are these, children from prior marriages and ways of estate planning that can help with that. But one of the things I think people should strongly consider if it's a second, even a first marriage, but it doesn't happen as often, but on a second marriage or even a third or fourth marriage, a prenuptial agreement, or a premarital agreement is a good idea, because most of the time people that are getting married for the second or third time have some assets.
Right.
And they've also sort of been through a process of finding out what happens if a marriage is dissolved. And so a prenuptial agreement, I think, is a good idea. And then, again, the idea of having better communication with all these family members, if that's possible, if they can work out differences and at least communicate with each other about, what's expected or what's going on, then it can alleviate some of the problems. Because you have to understand that when a will becomes effective, a person has died.
Right.
And that person isn't going to change anything anymore, and they're not going to be available to talk to and explain things. So if you haven't explained anything before you died, it can create some significant family issues.
Yeah. How about the idea that maybe each spouse should have their own attorney in putting together their estate plans?
Well, I think it's important to understand anytime you're dealing with multiple clients, there's a possibility of conflict of interest. And so that's something to discuss with people. So even in long-term marriages, that should at least be mentioned to them. If it's these other situations where you have different families with different children from different marriages, again, it's not an automatic. You're not forbidden from doing an estate plan for husband and wife together, as long as they understand the potential conflict and as long as there's not an actual conflict. But they're also entitled to do their own estate planning. They don't have to do estate planning together. They can do the separate estate planning. It leads sometimes to more unhappiness and confusion and problems because they don't necessarily know what the other person has done. As opposed to when you do it together, you have this. You at least know what's been said. But you do the best you can. If you can't decide and agree to do something together, and if there's not an actual conflict of interest, then you have to go out. If there is an actual conflict of interest, then you have to get your own attorneys to do it.
Okay. How could you be hurt tax-wise if you don't have a will or a trust?
Well, things have sort of changed a little bit in all of this. It used to be that a lot of estate planning included drafting to make certain that you got both estate tax credits, one at the first death and one at the second death. Nowadays, it's all a little bit more complicated because we have something in the tax law called portability.
Yes.
that may not still be around after January 1st. Again, it depends on what happens in Washington, but
Okay, so when we say January 1st, we're talking about January 1st of 2013, and we're talking now, this is July of 2012.
Right.
Go ahead.
right. So some of the provisions we have now are going to terminate at the end of 2012, and Congress will either have to continue them so that they don't terminate, or change the law in some way so that we know what the rules are, or if they don't do anything, then they lapse. These rules lapse, and we'll just be back to what the law was before. So it's all very kind of up in the air right now. But this portability idea, which is something that a lot of people think will stick around, allows a surviving spouse, after the first spouse dies, to decide to carry both credits forward to the second death. Now, there's a lot of complication about that, and confusion somewhat about how it will work. But the way the law is right now, you actually have to file an estate tax return to elect that portability.
Right.
So my concern would be, if you have no estate planning at all, you probably aren't thinking about any of these things. You probably haven't heard about any of these things.
Right.
So I would say that getting some kind of an estate plan in place, with the rules as complicated as they are, at least give you a chance of learning about these rules and then actually knowing what decisions you might have to make later. So I think there's some real advantage to doing some kind of estate planning.
Right. So, and another thing is, well, it's harder to write a will right now, I think, because of this estate tax situation. It used to be, I leave everything to mom, I leave everything to dad, leave whatever, and now it's like you almost need to contingency plan and try to guess a little bit in advance. You can, even though the ultimate, I guess, in flexibility is have this thing called an estate protector, where basically you said, well, I'm not sure what it's going to be, so I'm going to let him fix it or her fix it.
Yeah, it's an interesting idea, but it could possibly work.
Mm-hmm.
I know people do that. It also could possibly have some downsides to it as well. I mean,
Well, one of the downsides, of course, is that you're giving an awful lot of power to this individual and having a significant effect on your family. And it really needs to be an independent person.
right. And how do you find the right person to do that?
How do you find the right person to do it? I mean, it's very tricky. Okay, Bill, we're getting close to the end. I think a very important topic is, where should you keep your will?
Yeah, this is an interesting topic for me, because I have people come in to see me, and they've already done an estate plan.
Yes.
And they come in with this binder, and it's this nice binder, it's sort of leather, and it might have a zipper on it, and it's really nice and attractive with gold lettering on it. And it's their estate plan. And I look at that and I go, wow. That, to me, that's a marketing device, and it looks nice, it smells nice maybe, but what do you do with the darn thing?
Mm-hmm.
You put it on your bookshelf, and then anybody who comes into the library can read it. To me, you should keep your estate planning documents in a safe deposit box, and the people who need to have access to that if you die should know where that box is. Maybe have access through the bank, but in any event, know where it is so they can get access if you pass away, because the law allows for that. And so you need to have, unfortunately, not the binder, but a piece of paper that you can make it fit in the box and put it in there. And
maybe a copy in the binder.
yeah, but even that, I don't really like I mean, what are you going to do with the binder is my question. And I don't really like the idea that anybody who walks in your house can pick up your binder and read your estate plan. I mean, you can keep it in a desk drawer or something, I guess, but I just don't see the point, really. So I'm kind of knocking that idea. In all my 32 years, I've never really appreciated the binder.
Okay.
So, I think you definitely have to have an estate plan that can be put in a safe deposit box. That's where I would advise people to keep it.
Yeah. Now, a lot of attorneys traditionally have said, I'll take care of your will for you. What do you have to say about that?
Well, a lot of attorneys do that. It creates some issues. I think attorneys primarily do that. I'm letting the cat out of the box a little bit, but I think a lot of attorneys do that so that if something happens to the person, the family will have to come back to the attorney to get the will, and that sort of leads to the probate. I don't believe in that. I think the original document should be with the client. I keep a copy in my file, but the original should be with the client so that it can be found. Again, in a safe deposit box so that it's safe. It's not just going to be thrown away by somebody who doesn't like it. But also, if the client moves to another state or something like that, their estate plan isn't automatically invalid because they moved. And I don't necessarily, I'm not sure I'm going to know where they are if they die. They're not going to know where I am, because it could be 20 years from now. So I personally believe the client should have the original
Yeah,
documents.
attorneys die, attorneys move. I had that happen with one of my clients, and I mean, it was chaotic.
Right.
Because we couldn't find documents. I fortunately had a copy of one, but what they were going to be able to do with it, I wasn't sure.
Right.
So anyway, so you want to be sure that those are in a safe place, a safe deposit box, and it's one again that people know where it is, where the key is,
And the right people.
and the right people.
Right.
Okay. Well, I think we're about out of time. Maybe you'd like to just throw out a final thought as we wrap this thing up?
Well, estate planning, whether it's with a will or a trust, there's a whole different level of estate planning where people do what's called a living trust. I know you've probably had shows about that as well. And but any of this is complex. So again, you see people who try to do their own wills. You see what are called holographic wills, where people will handwrite a will, and they can be effective. They can accomplish what a person wants, but oftentimes anything that's done by a person themselves just ends up not being clear, or not being accurate, or not being legally correct. And so it isn't really worth it to not go to counsel or qualified people to get this kind of advice and get it done properly.
Okay, Bill, thanks for being my guest.
My pleasure.
Folks, this is an involved area, but I hope that we've given you something to think about and hopefully some motivation maybe to see your attorney or an attorney and see about having your will done. We'll see you next time on Financial Insider Weekly.